Okay, good morning to everyone. Today we have Professor Courtney. She's a assistant professor at Fordham University, the School of Law, and she specializes in many subjects actually, like data protection, cyber security, torts, personal injury, many subjects. And today she's going to talk to us about The Uncertain Judge, which is the title of a forthcoming paper, who is gaining a lot of attention, as I could see in the internet. So welcome. We are really glad to have you here. I hope it's the first of many times. And the usual format is about 45 minutes presentation, and then we open for the debate.
Great.
Okay. Thank you.
Well, thank you so much for having me here. I'm really delighted to be here, and thank you especially to Professor Jordi Ferrer and Henry Race for the invitation. I was so excited to receive it. You guys have such an amazing group here working on really interesting things. And my only regret is that I don't speak either Spanish or Catalan, so it makes it hard to read them until I've got an English translation available. But I hope to fix that oversight of mine in my education as soon as possible. So I'm really excited to talk to you today about The Uncertain Judge and its implications. So this paper is about a problem in judicial decision making, and it's the start of what for me is hopefully going to be a much bigger project. I have kind of a constellation of papers, works in progress right now, starting on working through some of the implications of the problems, and I hope eventually to turn it into a book that brings together a couple of strains of my research on judicial decision making and also actually on lying. That's my other big area of work. I usually emphasize for my law colleagues back in the States that the current paper is as common to philosophy and even legal philosophy, puts a problem on the table and defends the existence of the problem, but does not provide a solution except for the purpose of showing why coming up with a solution is going to be really difficult. So I'm sorry that you've flown me all this way for just problems, but I hope that's at least a fruitful start. So just at a high level, right? I take as my starting point that kind of contra Dworkin, right? Judges are not Herculean, right? Sometimes they're uncertain, not just about the facts or the law in the books or the interpretation of the law or whatever it is that we call all that, or the theories of adjudication, but even if somehow, right, they've managed to master all of that, they might still be uncertain about what they should do in light of it, right? When they're actually called to the moment of having to make a decision in a case, of having to sentence someone, of having to decide who wins or loses, and also what reasons they need to give, right, for that decision, at least in common law systems. This can come up in big cases, and some of the cases I'm going to talk about today are, at least in the U.S., right, big cases that go before the Supreme Court. It could come up before constitutional courts or whatever the higher level courts of review are. That's often what we tend to talk about, at least in the U.S. legal circles. But I want to emphasize that this is a problem not just for those judges, but for trial court judges too, right, who are managing busy dockets, and also thinking about things like not just, what to rule, but when to rule, when to push parties to settlement or mediation, right? All of those kind of smaller decisions that they make along the way. And oftentimes, right, especially for experienced jurists, their uncertainty doesn't cause a problem, right? Sort of one of the kind of enduring mysteries of the law is sort of how much agreement there is despite all the disagreement, at least as to outcomes. But sometimes these doubts have bite, and different theories about how to decide what I call jurisprudences will point in different directions, right? And so then the question kind of follows, well, what should a conscientious judge who's acting in good faith and trying to do whatever it is she's supposed to do as a judge, what should she do then? So that's the problem of normative uncertainty in judicial decision making. And to kick off our discussion, right, I'm going to explain in a little greater detail what I mean by normative uncertainty, and how it basically, I think, is unavoidable given certain relatively weak assumptions and defended against a couple of different kinds of skepticism that come up about the existence or the importance of the problem. I'm then going to show the power. I said I wasn't going to give you a solution, but I'm going to show the power of a potential solution, and then use it to illustrate why developing a solution is going to be really difficult. And then, time permitting, it would be rude to come all this way with problems only. I'm going to talk a little bit about some of the payoffs, about how even just seeing the problem kind of gives us a new lens on old problems, create some new problems that are really specific, I think, to legal philosophy and what we're doing in the legal academy. Okay, so what is normative uncertainty as contrasted to other kinds of uncertainty? I think it might help to start with kind of more familiar examples that are a little less complicated than judging in the moral space, right? So everyone's familiar with Kant's murderer at the door, right? Murderer shows up at my door. He wants to kill my friend who happens to be in my home, and I have a choice, right? I can either confirm for him that yes, my friend is here. I can lie to him and tell him my friend just went out to eat, or I can find some way of avoiding the question, right? I can merely mislead him. And sometimes I might not be sure about what to do because I don't know kind of what the empirical state of the world is, right? I think that I can lie, but only if merely misleading won't work. And the problem is I don't know if merely misleading will work, right? This is a kind of what I might call empirical or descriptive uncertainty. It's quite familiar. And right, this has given rise to a whole slew of debates about the nature of the moral ought. Is there an objective moral ought as distinct from the subjective moral ought? By which I mean, I don't mean to bring in meta-ethical baggage, I just mean, is the relevant ought in some sense agent relative or evidence relative, or is there kind of a evidence independent ought? And if there's both kinds, which one is central, right? So there's a whole body of research on that that's really interesting. That's not the kind of uncertainty that I'm talking about, although some similar issues arise. Normative uncertainty is a little different. So suppose, right, you know the relevant facts, you know that in this situation that merely misleading will work. You could also lie, it's kind of much of a muchness. But you're uncertain about what to do, right? You think that actually it's not a problem ever to lie to the murderer at the door. It's kind of a waste of time to even debate the question. But those strict Kantians, right? Maybe they have something to it, right? And so maybe you think, there's a chance that I should only merely mislead. I shouldn't lie in this situation. And so you're uncertain, not because you have any uncertainty about the consequences of your action or that kind of thing, the state of the world. It's just that you're not quite sure what it is that you ought to do. You're not sure what ethical rule applies. Maybe that's because there's competing moral theories. Like I suggested, consequentialism versus strict Kantianism, but of course there's a whole slew of other theories that would have this sort of same kind of divide, and so you don't quite know what to do. So that's normative uncertainty in moral or ethical decision making. I think the same thing happens for judges, and importantly, right, in the case for the merely moral agent, right, when you're deciding, should I be vegetarian, or if I am going to eat meat, should I limit myself to happy meat, like happily raised, organic, cage-free, etc. You're making, in some ways, right, that decision for yourself, even on views about categorical imperatives. That's still sort of a hypothetical type situation. That's not the case for judges, right? So conveniently, pending before the U.S. Supreme Court, the decision was just handed down, I think, while I was in transit. It seems to have been handed down. Right, there was a case pending about whether or not the state of California could limit the pork products sold to happy pork. And of course, the decision in that case, right, isn't going to just decide for Californians whether or not they can limit the food products to happy pork, but whether, say, the state of New York can limit eggs to happy eggs, and a whole variety of other things depending on how broadly or narrowly the court decided to rule. So the problem in judicial decision-making arises, I think, pretty straightforwardly from three relatively thin assumptions, or at least assumptions that I'm trying to make as thin as possible. So the first of these is that judicial decisions can be coherently criticized. right? So that there is such a thing as a judicial ought, and it's not totally incoherent. We have a basis for criticizing judges' decisions. That a conscientious judge's sole aim is to do whatever it is that she ought to do, and that a conscientious judge behaves or should behave rationally. So I haven't in this paper defended these assumptions. Eventually, if I write a book, I will need to do that. But I want to say a couple of things about them. So as to the first, right, I'm trying to remain as agnostic as possible about the judicial ought. Some of this might be obvious, right? I'm not trying to get into the content of what the right jurisprudence is. That's the work that happens in law reviews. Should you be a textualist? Should you be a proposivist? Not getting into those debates, right? What I have to say sort of applies regardless of which schools of jurisprudence you think are more or less plausible. I'm also trying, I think critically, especially for legal philosophers, right, to remain as agnostic as possible about the forms that the jurisprudences take or what grounds them, right, sort of the meta jurisprudence. And so, for example, I don't take sides in the Hart-Dworkin debate between positivists and like natural law theorists. I think what I have to say applies regardless. I don't take part in the modern, I'm trying to avoid, right, the modern spin-off debate from people like Greenberg and Hershowitz about whether there even is a domain of like legal obligations that's somehow distinct from moral obligations, right? I've shoved all of this down into the idea of a jurisprudence, right? A jurisprudence is just all things considered, what should the judge do, however we understand that. I also, some of my colleagues, right, who are practicing attorneys, right, they think these theories are crazy altogether. I don't take sides in those debates, right? You think maybe judges should be operating on situation sense and working backwards to rules? That's fine, right? You've got a view about what the judge should be doing. You think judge calls balls and strikes? Right, some of my more originalist or conservative colleagues say this, like there's no normative judgment. How can this normative uncertainty be a problem? Actually, you've got a really strong view about what the judge should do. You think the judge should call balls and strikes, right? And as long as you don't know exactly fully what that means, as Chief Justice Roberts actually admitted from the bench in the Dobbs arguments, and again in his concurrence in the Dobbs case, you've got normative uncertainty, right? You're not quite sure what it is that you ought to do. And this, right, I really just mean it in that thin sense. So as long as you think that it's not a total free-for-all, we're going to get this off the ground. The second, right, I'm not a cynic. This isn't a paper for cynics. There may be judges who do not aim at whatever it is that they're supposed to do. Strong evidence that such judges exist, but I'm concerned about the judge that is aiming at whatever she ought to do. And I think there are, I hope, there are a number of those still on the bench. And then the third, a conscientious judge behaves or should behave rationally. And here, I'm trying to kind of remain as agnostic for now about debates over rationality. It really just means something like doesn't act to undermine their aims, right? If you have an aim, you're not going to kind of act to undermine it. So with these three assumptions, right, we can get the basic question off the ground. What should a judge do in this case? And so whatever your views about plausible candidates for the correct jurisprudence and all that entails, right, my question for you is the same. What should a judge rationally do when she has doubts about which, if any, of the candidate jurisprudences is the correct one? So that's the problem. And at this point, right, most people, or a lot of people start to have the reaction that this isn't like a new problem or a real problem for kind of any number of reasons. There are three big ones, right? So the first is you might think such cases are unlikely to arise, or that you don't have this kind of uncertainty. This is kind of like an empirical or descriptive kind of skepticism, right? You think that the problem could theoretically exist, it just doesn't actually exist. Or you might have a theoretical skepticism, right? That you might think your preferred jurisprudence or view about how judges should decide cases kind of already takes this into account. Or you might think the answer is obvious. Right, sure, yeah, there's a problem, but swallow your doubts and go with the jurisprudence that you think is most likely to be correct. So I'm going to talk through each of these skepticisms in turn. So the first one is kind of this empirical skepticism. This is the late Justice Scalia, right, who was known for having really strong views about the right way to approach, in particular, constitutional interpretation and statutory interpretation. And I think the reaction that you know how to decide a case is kind of common among really experienced jurists and also legal scholars, where you spent a lot of time kind of working out and mediating what you think are the more plausible jurisprudences or not. And so you think that you might lack normative uncertainty because you're not uncertain about which jurisprudence to follow. You've eliminated the others. I think this is to be expected. I think particularly in law, right? It's easy to kind of confuse deciding something with being certain that you've decided it correctly. And like I said at the outset, there's pervasive agreement about the law, and that's even as between different different schools of thought. The common law constitutionalists and the originalists do come together on actually quite a lot of things. And so somebody who's particularly developed views, that's eliminated large swaths of jurisprudences, might find that, the cases where they actually see their uncertainty or the uncertainty has bite arise in fewer cases. But even, right, Justice Scalia, he had some doubts. Right, he didn't think that a case where he was called upon to rule about flogging the constitutionality of flogging was likely to come up. Almost certainly permitted at the time of the founding, but he couldn't quite see himself going along with sort of that original view about what cruel and unusual punishment was either. So right, if pressed, I think most empirical skeptics will admit to at least some ambiguity. And another way of thinking about this is most people think in terms of kind of incomplete jurisprudences, right? We don't have fully worked out across the possible range of cases what exactly to do and how to balance different kinds of trade-offs that we would need to make, and so we kind of apply it as we go, right? And this relates, right, to some of the questions about defeasibility in legal reasoning, right? Just because we have a set of rules, we haven't ex ante been able to figure out how they apply across the range of cases, and so there's a sense in which whenever a judge is ruling on a case, they're kind of necessarily building as they go. One way to model this, and this is a way that I do in the paper, is to kind of assume complete jurisprudences and model this sort of building as being uncertain as between different complete jurisprudences that you might follow. And so, right, a skeptic might have thought, gee, my choices were between jurisprudence A and jurisprudence B. For an originalist, between something like ordinary meaning textualism and term of art textualism. And then this new case that comes before me just shows, oh, gee, neither of those were quite right. Some hybrid theory or pluralist theory or a refined theory is the right way to go. And the reason I model it this way is, right, you might think of this as sort of defining something new, but in a sense, the conceptual space was always there. We just didn't see it yet. And so you can think of, right, this process as iterative. Eventually, there's going to come a point, though, because, right, the nature of legal reasoning and jurisprudence is they have to have some minimal level of coherence, right? It's not totally ad hoc, right? Like cases should be treated alike, where there's going to be a difficult trade-off between which theory is actually the correct one, whether you got it wrong in the past or you're getting it right now. And so that's part of why I model it the way that I do. And so I think a lot of empirical skeptics will maybe hopefully realize that they're not actually skeptics at all. They just didn't really kind of appreciate the nature of the problem. Others are going to resist, right? They're going to take a similar approach to versions of jurisprudences as they do to schools, adjudicate between them, pick the best one, and just go with their favorite. And so they begin to think, well, wait a minute, maybe there's something a little incoherent about the problem, right? Isn't the question of what I should do when I don't know what to do really just the same question as what should I do? And so I think there are a few sort of responses. In the US, and I apologize that I don't know what the equivalent Spanish doctrines are, but we have canons of, say, pragmatism or minimalism, constitutional avoidance, deference. And so you might think like, gee, these are kind of solutions, right? That's sort of the answer that my jurisprudence provides. And I think, well, yeah, sure, maybe. But you might still, first of all, be uncertain about when and how to apply them, right? That's certainly something that gets debated quite a lot. But more fundamentally, I wonder if they've been mischaracterized, because I think Weatherson's argument might be helpful here in thinking through what sort of a problem about jurisprudence is that take into account uncertainty about whether that jurisprudence is the correct one. This sort of goes to the theoretical skeptic. So the argument, right, has three premises and a conclusion. The first two are about what you're allowed to do. So one of them, it's definitely true that you can remand for further proceedings. On the other, it's likely true that you could reverse in favor of one of the parties. The third premise is about what you should do when you're not certain about what you should do. And so, right, there's a placeholder for the decision rule. And then, right, when we plug in the decision rule, we'll get a conclusion about what the judge ought to do. And so is Brian Weatherson. He's one of the moral philosophers that's been working on the problem in the moral philosophy space as he observes, look, there's sort of an essential intuition driving the question about normative uncertainty, that basically uncertainty sometimes, right, requires you to do something other than what you think is right or permitted. And so it sort of assumes that there's probably going to be a decision rule of this kind of sort, like caution. If you have a choice between two options, one of which might be wrong and the other of which is definitely right, go with the option that's definitely right. Right? It'd be wrong to choose the one that's, in this case, it says it's the first option, but actually it's the second option in my premises here. The problem is that once you fill this in, right, premise 2 and conclusion 4 can't both be true, right? It can't be the case that reversing is likely permissible, and reversing is definitely not permissible, right? That seems to commit the judge or whoever is following this, right, to an incoherent set of views. And the solution here is, as Weatherson notes before making a different kind of argument, is to distinguish between two kinds of oughts, right? So one is that judicial ought that I was talking about, and the other is the rational ought. And so it can be true, right? Lines 2, 3, and 4 can all be true, even where the decision rule is something like caution, right? By recognizing that these are two different senses of what I ought to do. What should I do jurisprudentially or judicially, and what should I do rationally, given my uncertainty about what I should do judicially or jurisprudentially. Okay. I'm going to flag here that Weatherson thinks there are other reasons to reject this distinction in the moral case. I don't think they go through in the case of judicial decision making. I'm happy to talk about that more in QA, but in the interest of time, I'll press on. I'm just going to flag that. So then, right, supposing you agree with me that there is a problem, right, it's theoretically coherent and it obtains, you might still have kind of the reaction that the solution is obvious. So do you guys have The Good Place? Have you seen The Good Place? Yeah, some people have, right? Yeah, right, it's sort of the punchline, right? This, for those who have not seen The Good Place, which I highly recommend, right? This is Chidi, the resident philosopher who can't decide anything because he's so uncertain, like at a deep level, about what it is that he ought to do. And right, the punchline is like, look, Chidi, just pick. Okay? Go with whatever your preferred jurisprudence recommends. The problem is, and this I guess is my punchline, is Chidi is right to be worried about his uncertainty, because ignoring it makes two mistakes. So the first is that it ignores your credences. So if we can think of a simple case, right, deciding between the plaintiff and the defendant, and you have credences in two different jurisprudences, you think one is more likely than two. I don't really care about the distribution. In some cases, right, according to one of your jurisprudences, we'll say it's your favored one, jurisprudence 1, the case is in complete equipoise, right? You have total discretion, not cabined by anything else. Once you've taken into account all the things that you think, right, cabin your discretion to choose either side. And in the other, according to jurisprudence 2, one of the options is wrong. And so, right, to ignore your credences means basically if your aim is to do whatever it is you jurisprudentially ought to do, and you're not quite certain what that is, the rational thing here seems to be to find for the plaintiff, right? By doing that, you guarantee satisfaction of your aim. By failing to do that, you take an unnecessary risk with no benefit, no benefit at all to your aim, right? Because you might be wrong. Cases like this, I think, are relatively unusual. The bigger problem is actually this one. it ignores the cost of error, right? It assumes that all jurisprudences agree about the stakes in a given case. And so here, right, you might think according to your favored jurisprudence, right, the jurisprudences disagree about what it is that you ought to do. But according to your favored jurisprudence, right, it's a relatively small mistake, not insurmountable. But according to the second jurisprudence, it would be a huge mistake to go against its recommendations, right? And we can see think about the kind of jurisprudences where that's probably true, right? One that thought fit was the only thing that mattered, one that thought moral criteria were relevant to fit. We can see how they might come apart on what the right thing to do is. One reaction, right, is, well, gee, that tells us that we should perhaps revise our jurisprudences or what we think the plausible ones are. But even if not, right, you're really pretty sure about jurisprudence 1. You should be taking this information into account. Now, I don't have necessarily an answer for when you should flip, right? When the fact that your less favored jurisprudence says something is a big mistake means that you should change and follow its dictates, right? Maybe if you believed it more strongly, maybe if the stakes were even higher, right? That's part of finding the solution. But the point is that it's at the very least irrational to ignore this information that you have. Okay. So what's the solution? That's a little awkward. Yeah, I don't know. I don't know what the solution is. In my defense, in the moral space, which I flagged, right, is easier. Those moral philosophers, they got things really easy because they're not making rules for everybody else. Right, the leading solutions have taken like a book to defend and to explain and defend. And the piece that you guys read is just an article, so I didn't have that kind of space. But also, it's really hard. So let's talk about why it's really hard. And to do so, I'm gonna look at a possible solution. I want to be clear because this always gets confused. I am not suggesting this is the solution, right? I'm not defending this, at least not yet, possibly never. Right, this builds on Lockhart's work. He doesn't fully explain jurisprudences or I think understand some of the difficulties of the legal case, but it's a nice solution, right? It's based on maximizing kind of expected utility, and I've picked it because it's at least familiar, right? At least in the US, we have this thing called the hand formula that gets taught in first-year tort classes. I teach it to my students, which is basically a kind of cost-benefit analysis. And so the idea is that a choice of action is rational if and only if the expected degree of judicial rightness is at least as great as that of any of the other options, right? And note, of course, that we're making a bunch of assumptions about the jurisprudences we're uncertain between, like that they admit of degrees and they satisfy all of the axioms of expected utility. Lockhart and others have developed sort of corollary principles for when you don't have that level of information, but just for the sake of familiarity, because those methods get a little down to sort of voting procedures that at least not all of my law students are familiar with. We'll run with this. And I'm going to apply it to a case called Brown versus Board of Education, which, right, you may be familiar with. It's the big landmark US Supreme Court case that struck down separate but equal, the doctrine of separate but equal, right, the really racist doctrine. And think about a judge, right, who might have been deciding it at the time. And I've made kind of stylized examples of jurisprudences. I don't mean to say that this is actually the view, right? A lot of work has been done to defend Brown from an originalist perspective, but we can say, like, look, there's three possibilities, these three different jurisprudences, and these are the degrees of judicial rightness that they would assign. And we can imagine a Judge Hector, or a Justice Hector, sitting on the court, and he's got the following credences. I've borrowed, right, I'm modeling credences as probabilities. I've assumed that these are mutually exclusive jurisprudences, kind of following formal epistemology. Future work, right, will need, as we think about or work on this problem more, we'll need to actually get into the question of whether to use epistemic or actual credences and whether you can actually use probabilities to model them, but just for sake of illustration, right? That's what I'm doing here. So you have these numbers, you plug and chug, and at least for Hector, right, unsurprisingly, I'm going to bounce back for a sec, right? His favorite theory said that he should overrule Plessy. That's the case that introduced the doctrine of separate but equal, and unsurprisingly, right, given the stakes and his credences, he can maximize the expected judicial rightness of overruling Plessy as higher. even though he might be a little uncertain about which jurisprudence applies, it's pretty clear what he should do as a rational matter. Okay. Okay, well that seems pretty obvious. Let's talk about a different justice. Let's call him Justice Diomedes. Note that the chart stays exactly the same, right? What a jurisprudence says about the stakes in a given case is particular to the jurisprudence, not to the person who believes in it. The thing that changes are the credences. And so Justice Diomedes is more of an originalist justice, and on his favored theory, the correct thing to do here is uphold Plessy, right? But he has doubts whether that's true, and other jurisprudences in which he has some level of credence, right, point in the other direction, have different things to say about the stakes. When you plug and chug the numbers, it's still close, but this is a case where Justice Diomedes could flip, right? He might follow a jurisprudence that is not his favored jurisprudence, right? Because that's the way to maximize the expected judicial rightness, given his uncertainty about what it is that he ought to do. Now, I'm not saying that this is actually what happened in adjudicating Brown, but I will observe that it's kind of interesting, because one of sort of the enduring mysteries of Brown is that the justices that were deciding the case, according to their own private papers, were really uncertain about how to reach the result that they did. They were really concerned that it might be lawless because they saw themselves as needing to overrule this decision Plessy, and in their stated opinion, they don't expressly say that they're doing it, but kind of as a matter of fact, right, they essentially are, since Plessy relied on an analogy to facts just like those presented in Brown. And so this is sort of an interesting way that those justices might have reached the conclusion they did, no, without changing anything or cherry picking about the strength of their beliefs in different theories. Okay, so that's kind of a cool result. So why am I not defending it? Well, I'm not defending it, right, because it has all the familiar shortcomings that arise with respect to expected utility theory, right? So for example, there's really strong assumptions that there could even be such a thing as complete jurisprudences. Not entirely sure about that. But also, and more importantly, right, there's the problem of intertheoretic comparison. So first of all, not all theories are going to admit of degrees, right? Some deontic theories don't admit of degrees, right? There are side constraints, and they don't necessarily, although, right, some work has been done by, say, Tom Herka on, more importantly wrong, more importantly right. Not everyone agrees with that kind of picture. I don't really know how you would model out what a virtue ethics theory would say in this kind of context. And so comparison across theories, we got to get them on the same scale, or at least even speaking kind of the same language. Even if we can do that, right, there's still going to be problems where not all scales for a theory have the same range, and then normalizing them is going to create big problems where there may be swamping effects insofar as some theories have bigger scales, and those bigger scales may end up dominating as a result. And that's all before you get to the peculiar problems that arise in the case of judicial decision making, right? Like I said, it's not merely the judge is not merely a moral decision maker. They've got to give reasons, and the reasons that they choose to give, at least in a common law system, right, are themselves generative of rules that apply going forward. So I don't have a solution, but I think it'd be rude to have you guys fly me all this way and not give you any kind of payoff. Here we go, implications. So I'm going to talk about a case called Google versus Oracle. Google versus Oracle is a major copyright. My substantive homeroom, as it were, is in intellectual property law and law and technology. And so this was a big case that came before the Supreme Court. Basically comes down to, in layman terms, whether you can copyright basic commands and command structure hierarchies. What do I mean by that? You know the menus, like where it's like file, save, and print, right? It's sort of those commands, copy, print, or quit, and where they're located is one way of thinking about it. That's really simplified. I know it's not as sexy as some of the big cases that we like to discuss about rights and human rights and that kind of thing, but it affects really important things in your life, like the cost of your phone. And if you're like my dad and couldn't find the print button the first time, you really don't want to incentivize the coders to move it on you, right? So really, really important, right? Practically important. In any event, the case presented two issues. There's a copyrightability issue, whether the copyright software at issue could be copyrighted, and then the fair use. Even if it was copyrightable and Oracle had the copyright in it, whether or not Google's use of it, the copying of the specific things that Google copied, whether that was what's called fair use, and so therefore not infringing. And so we can think about a judge that was somewhat uncertain between a couple of approaches to deciding the case, and we can simplify kind of their scope of choice to 3 options, right? One in favor of the plaintiff, finding it copyrightable and not fair use, and then 2 options, finding in favor of the defendant, one that does so on copyright grounds, one that does so on fair use grounds. And so you have a judge that's uncertain between the two approaches to deciding the cases. We'll call one the Boudin jurisprudence and the other the Breyer jurisprudence. Judge Boudin wrote a really famous opinion in an earlier version of this case called Lotus. Justice Breyer wrote the majority in the actual Google versus Oracle case. And so these are named in homage, right? And on the Boudin jurisprudence, at least as I glean from his Lotus comments, right, you got to find for the defendant. Better to find on copyrightable grounds, but maybe this is important enough that the standard also works. That argument seems to be fine. And on the Breyer jurisprudence, as people like to complain about Justice Breyer loves standards all day long, and so maybe that's the better. We could talk about when it would make sense for Justice Boudin, a judge who followed the Boudin jurisprudence to flip, but I want to focus on something actually structural about this. Let's suppose for a moment that this is a case where Boudin would flip, where he would vote along with fair use as a matter of law, even though his preferred jurisprudence favors finding software not copyrightable. There's 2 things that we can say about the decision, right? One is we can say, as a matter of jurisprudence, he didn't do the right thing. We can also say, had we been in his shoes, we might have done the same. Wexler would have said we were incoherent, but I suggest to you, right, by recognizing the problem of normative uncertainty, we can have our cake and eat it too, because really what we're doing is we're making 2 different kinds of critiques of what was done, right? One is at the level of jurisprudence, sort of what is justified as a matter of legal principles, to the extent you think they're relevant moral principles, etc., anything that you think that it's relevant that goes into what a judge should be doing qua judge. And the other's at the level of rationality, right? Given uncertainty about what you should be doing qua judge, what's rational for you to do? This kind of dual critique structure has a lot of different implications. Those are the things that I'm actually really interested in working on now. So here's one. I sort of previewed it, right? Some of our legal doctrines or things that we thought were sort of jurisprudential or legal, like minimalism or avoidance or deference, sure, maybe they're justified as matters of jurisprudence, but maybe they're better justified as rational approaches to dealing with uncertainty. And if that's the case, right, that's going to have lots of implications for their legal authority or their ability to kind of act as sources of validity, and whether they should be applied going forward in similar cases, and what the right criterion for similarity are. I'm working on sort of 2 papers in this vein, one about trying to think through the categorization of some of these approaches, and one thinking about whether or not a judge can actually ever give the sort of true reasoning process that they did for putting down the reasons that are in the decision. I think as a matter of analytic necessity, they probably can. Here's another. So, right, I said that I do IP and law and tech. And so a lot of my friends and colleagues have this kind of reaction, right, with machine learning, no problem, we can't solve. I've got a paper in the works on automating the uncertain judge, which is basically not so fast. Note how I said there are 2 levels, and I called into question whether or not everything that we're thinking of as being jurisprudential is in fact jurisprudential rather than rational, and that has implications for whether we can rely on it as sources of validity. Well, this creates a design problem. I'm not chicken little about AI. I'm not bullishly optimistic about AI. I'm just saying, like, look, if you want to do AI, we philosophers, we've got a problem for you, because, right, 2 levels means 2 types of tools, 2 benchmarks, and 2 times the trouble for data selection, structure, and training. I've been workshopping this with the IP and the law and tech crowds this last year. So those, right, so there's a bunch of kind of general jurisprudence implications, right, for legal philosophy. This has some practical implications, certainly for law and technology. I don't have a solution. It's really hard. But in short, there's this problem. solving. It's really hard, and it has a host of implications that I'm starting to work on, and I hope some of you may join me in future in discussing. So thank you so much. I'm looking forward to our discussion, and if you want to follow up with me after, you can find me on Twitter, and now actually also the law Mastodon under that once I figure out how to use Mastodon, or by the old-fashioned email. I look forward to talking more.
Thank you.